Okay, welcome back. Welcome, James, for your verbal response to the evidence presented so far. We're in your hands.
Actually, Mr. Chair, I'd like to probably start by turning it over to the panel first to see which specific questions that they, burning questions that they will have, or information that they would like from the reporting officers.
Sure. I mean, I sort of feel like I've given a bit of a direction from my perspective, but I'll poll the other panel members and just start off here.
Well, one thing that I wouldn't mind a response, and you don't do it as part of your verbal, but as part of the written, is the tabled statements from submitters that we haven't heard from. There's a few not rats and mice, but issues, I guess, that they've raised there. Even though they didn't appear before us, I think they deserve a response. So don't forget about them, please.
Yeah, are there any particular issues to out of them, or just for coverage sake?
I think foodstuffs had some stuff they wanted to talk about. I mean, they're mostly in support, but they, talking about a discretionary activity status for, frontage to the coastal marine area, for buildings and structures that do not comply, all those sort of things. So, Steve Tuck's letter, there was some clarification there about a typo and on the schedule, potentially. Yeah, just double check them, really.
Yes.
Nothing major.
Oh, yes, please. Yeah, I suppose for me it would be the significant sites, like what's the kind of timeline and what mechanism that can happen. The Rangi Toto Pa, and not sure what you can do about Te Aurere, but that one. Nina's gone home, and I did ask her about it. I won't tell you what she said, but that would be good to have an outcome. Thank you.
Thank you.
Kia ora, thank you. So, for the SESMs, if our planner can look at the proposed objectives and policies from Top Energy in regards to infrastructure, and in particular development of new infrastructure. Existing makes sense. Let's have a look at that and have a response to that. Also, Te Aukori settlement information, so making reference this morning around where there's sole ownership, and Tipene had flagged that that's captured in the settlements. So just check that and look at that.
For clarification, would you like us to supply that information directly to you? Is there a specific task that comes out of that?
I suppose the specific task is where they've specifically said sole ownership, and that's where they would have crossed out the other requesting parties. They signalled that those sites are in their settlement, so just that alignment and checking that, reinforcing that situation.
So the task is that we will identify those ones that are sole ownership from the settlement. Yes.
Sure. Thank you.
Yeah, and for me, I'll just sort of reiterate, but I think it's already on radars now, the dry stone. I think you've obviously made a few steps towards answering those questions. The conversations I was having with Mr. Riddell regarding the use of guidelines and how, if that is to be a good process, how would you recognise them and how would you allow that to be a dynamic document? As Mr. Brown says it should be. Then this question of assessment criteria, which isn't a part of the plan, and assessment criteria aren't matters of discretion, but confirm that. And how, but having said that, how you respond to his questions about bringing in a little bit more direction into policies, whether you have a view on that. The discussions we're having yesterday with the top energy, and you would have watched that backwards and forth, about that whole question of a very resilient, they offered a very resilient internal process with regards to archaeology, and they backed that up with evidence that we have to accept as true. But yet it sounded like it was a little bit like when it came to trees, and I asked the question as to why, and whether that deserves some form. I think we're better advised now as to what level 4 arborist is, so maybe that can be confirmed, so that's in writing. And then there's this question of the corridor, what we say, the width of flexibility, 3 metres either side. Is that metric? And then the obvious really pressing one is this question of excavation. So I asked here, I thought Federated Farms, I thought they were a good witness to ask the question, do you approve of the method? And I think the answer we got from them was yes, and I think we've got a general sort of vibe, if I can use that term, that they're not opposed to the method as opposed to area and volume. They've just got this problem of depth, and I think we're probably wrestling with that already. But just to formalise that we really like some comment on that. And if depth creates a particular problem, then do you go back to one of the other methods? Federated Farmers talked about the soil type. I'd like some comment on that. I think it potentially solves some problems, but it might also create a whole set of new ones. I'd like to hear your views on the first instance.
I think it's fair to say, Mr. Chair, that in our discussions, I'll also defer to the reporting officer shortly as well, is that we are casting a relatively broad net beyond depth into what other methods would be useful while still achieving the outcome sought. So we're probably, I appreciate you've probably given us a very targeted and quite narrow set of guidance, but we're probably going to look to go a bit wider if we need to.
Yeah, no, that's what I was indicating.
Yeah.
Then is that if there's a problem with the depth, the actual depth, making that work, then you have to go back and look at some of those other methods.
Yeah.
And that seems to be an appropriate thing to do.
Thank you.
Yeah, and I just wanted to double check and cover everything. Okay.
Just about the tree process, I want to go back to that. How much we've heard essentially that they have arborists on site for the 170 odd trees across the district. How much detail are you really after in terms of feedback on their own process?
Well, I think we have to evaluate what they offer to us in the evidence. But I'm just acknowledging that I thought it was a little bit lighter than the archaeological one. I made that clear to them, I think, yesterday.
Thank you. Yeah.
And the other thing I think to think about is how robust is an internal process of a private organisation, given that those organisations are commercial entities that can be brought in, so and management change and management priorities change, whereas there's a little bit more robustness in district planning. Okay, that's me.
And to acknowledge, it does appear on the face of it that it's a strong process, so not without issues, but just acknowledge that it is a strong process.
Yeah, I mean, in my former life, I used to work at DOC, and I used to turn up at district council hearings and said, you make us require resource consents, earthworks, tracks, we're the Palm Conservation, we're subject to the Conservation Act. You've got no idea what we have to do in our internal processes just before we get, our internal processes are stricter than your resource consent processes, have regard to. But they are a statutory organisation, they have their own governing statute, and the corollary of that is top energy is a private corporation.
Yes, section 4 is quite useful for that, sir. I know it well. Those processes does provide you with some support. Are there any further questions, panel?
I said two, which haven't had a lot of airtime, but I think they're important. In terms of consistency across the plan, artificial crop protection structures, the rule that's in heritage area overlays, really just to make sure that what's being put in here is consistent with what's in the rural. So following that hearing, we've heard a lot of evidence about that topic, whether this is consistent with where you're recommending we go there, or whether it's a little bit different. Sure, it's looking at different issues, heritage issues, but whether we're not kind of making this one unattainable, but the other one sort of thing. And the other one, the second one was the colours, which are recommended to go into the appendix, just in terms of what the format of that might look like as an appendix in the plan formally. And we've got Mr. Brown's report, but how would that look as a chapter or an appendix in the plan? What number would it be, all that sort of stuff?
Thank you. I think that's something that we've been tasked with. So yeah, that should be on the radar already. Great. Thank you.
And the alert layer, the commentary around alert layers, is that a viable option, not a viable option? I mean, just the commentaries on it. Yeah, today from Waitangi. Understand the merits and stuff, but actually implementation practicality can also be a challenge. And also, I think what was raised yesterday by Mr. Haynes around who's monitoring and overseeing scheduled sites of significance and probably heritage sites as well. Just some commentary around that.
Yeah, look, I've spoken to the reporting officer, and we feel that it's quite important for that particular situation to understand as much as we can post what occurred, what happened. So we've got an understanding of the strengths and weaknesses of our framework and potentially how it's implemented. I think we probably have an inkling on how often those sites get monitored. But yes, thank you.
Thank you.
And also in the obvious questions category, we'd like to know where you finally stand on the regional matter, what that's, anything else that's meeting obviously you'd like to bring to our attention. So look, I think we've covered all of them on this. Yeah, thank you very much. Unless there's something else you
absolutely
want to bring up that we haven't brought up?
Absolutely, Mr. Chair. I'm sure our hard-working reporting officers have other or additional matters they might wish to highlight. I think I'll turn over first to Ms. Pearson.
Thank you, James. I'm not going to respond to all the questions that I've heard today and not all of the pieces of evidence, but I think it's important for everybody who gave up their time to come to this hearing to understand that I am listening and I have heard the evidence that's come, and it is definitely going to be shaping my thinking as things come out in the right of reply. And one of the key messages for me that has really come through really strongly over the last few days is that the importance of bringing your communities and your iwi and hapu along on the journey when you are introducing provisions that manage historic heritage, and that these provisions need buy-in for people to work. They don't work if you've alienated the very community that you're asking to be kaitiaki of these places. So that, I guess, starting point is going to be framing a lot of my responses to the evidence that was heard over the last 2 days. I think there are some Commissioner questions that I can almost answer right off the bat, just to cover them off. Some from right at the beginning and some just from right now. There was a question from Commissioner Kensington about historical versus historic, and I think I've got to the bottom of it. It's not a great outcome, but the answer is actually an internal inconsistency with the National Planning Standards. So Part 4 of the National Planning Standards, the district plan structure states that the chapter under the historical and cultural values section should be called a historical heritage chapter. But then you get conflicting direction in Part 7, which says that if the following matters are addressed, they must be located in the historic heritage chapter. So there is conflicting direction in there about historic versus historical, and really where the PDP has come down and where I would support it staying is using the historic heritage term, as that is better aligned with the RMA and the definition in the PDP.
That was what was up on the screen with the Heritage
Exactly.
today, in part of the act that was up there.
Yeah.
Heritage.
And if you've got directions in both directions, then either one can be wrong.
Exactly. Yeah.
Yes.
So,
Either can be wrong. Well,
but I think given now at least I've got to the bottom of why it's written the way it's written.
it just doesn't read right. To be honest, the vibe of historical chapter. Just
Close to hysterical.
oh, that's going to
Well, I might just add to that is that in terms of how we as practitioners see it, historical is talking about events that have happened in the past, whereas historic is providing a value to that.
I think you should put that in writing, and I'm not joking out. That's quite a apt description. Thank you.
I think one of the next questions was, obviously I will provide a more fulsome response with respect to dry stone walls in my right of reply. I've already sort of signalled during the hearing that I think there is a problem with the definition of dry stone walls in the Waitangi example, particularly in terms of it not being time bound to when that wall may have originally been prepared. And in some of the discussions I've had with Mr. Brown and during the course of this hearing, there are other practical issues with trying to distinguish when a wall was built, how often it's been repaired, rebuilt over time. I don't think anyone's disagreeing that dry stone walls have got historic heritage values. That's not really what's in contention. But for me, it would be quite a large change to go for a blanket rule that applied completely across the entire Farnworth district and could potentially, if the definitions weren't right and the rules weren't tight, pick up situations raised by Mr. Jack earlier where they're quite modern constructions, and simply because they're chosen to build them with the dry stone method, they end up getting picked up inadvertently, and they're not actually the sorts of historic heritage values that those rules were trying to target. So given that if this was something that the council looked at doing in the future, I feel like the full Schedule 1 process to gauge the sentiment of the communities and the entire district that would be affected would be more appropriate than bringing it in partway through this process. So that's, I guess, the flavour of where my right of reply is likely to go. Just want to see, do you have any comments on the dry stone wall, some of those issues?
Yeah, Ms. Pearson's quite right. I think again, the question is, are you protecting your tradition or a feature in terms of its fabric? And the tradition of constructing the stone wall, as we can see in Mason's its own presentation, they built one 6 months ago. So, but to be able to determine that in the field and say, okay, this is a particular age is problematic, and you'd have to do considerable amount of research, global amount of questions.
No.
We learned that from last year.
Should we take
The next one of really great voice. Bring up that awesome voice. You should die for it, please go.
So anyway, what I was saying is, problematically, so I think there's a natural justice issue as well in relative to FNDC, but I would not be particularly comfortable professionally to say that every single stone wall in the environment region because it might have heritage values. I think it's putting the onus onto the private landowner when actually I think more what would need to be done.
Yeah, because I mean, the original question was, doesn't need a definition. But if your position is, I think we need to be thinking more about how we, because here's the thing, a definition that would work would actually be like a rule.
Yes.
Because it would be telling you what is and what isn't.
Yeah.
And so if you think that you need to go through a process first about how you would go about, I think this is what you're telling us, is that we need to go through a process first.
Yes.
A transparent process. Yeah. About how you would go about and where you would go about and define what it is you're protecting before you use the definition.
Yes.
Absolutely, and I think obviously Heritage New Zealand has brought up the Whangarei example, and other councils have done this, and I don't think anyone's disagreeing that there is a merit in potentially investigating that, but I don't think it's as simplistic as a lift and shift and just picking up because somebody else has done it before, then it will also work for the final. So I think that's as far as I'll go on that one. There was a question quite rightly raised by Commissioner Kensington about the missing policy for Rawiri. That does appear to be an oversight. What the chapter does have is quite a comprehensive background in the overview of the values that Rawiri was identified for. So it's not that it was completely missed, but it's just ended up in a non-statutory part of the chapter as opposed to statutory part. I think one of the reasons it may have been missed is that the operative district plan had more generic policy direction around heritage precincts. It didn't take this model and say, here's the policy for Rawiri, here's the policy for Pururoa, here's the policy. It didn't do that. It said, when you are thinking about, generally paraphrasing, when you are thinking about doing development in heritage precincts, you should think about these things. And in some of them, they sort of say, you know, in areas like Rawiri or like Pururoa, but there weren't, I guess there isn't an operative policy that I can pick up and move through, but I also need to do a bit of an investigation into scope to see, because this is not a clause 16 type issue in my mind. I suspect that I may find some scope, and I would like to, and that is what I would be looking at doing. But in terms of exactly what that wording looks like, we'll probably be drawing from the information that's already there in the overview, because that's essentially what the policy direction for all of the other policies does.
And if that's the way you approach it, then there'd be no surprises. That's
There would be no surprises.
Nothing new.
Nothing new.
So the scope issue will be not what you say, but where it's put, as opposed as a policy versus an overview.
It's already in the overview.
That's what I meant.
Yeah.
That's my point. It wouldn't be about what you say.
No.
It's about where you say it.
Yes. And whether or not I had scope to introduce a new policy as part of maybe a broader submission point
So
about recognising Rawiri.
So that narrows your scope focus a little bit.
Yes. Thank you.
You're on the same.
I think the next, I've obviously picked up on Chairman Scott's question about is council under obligation to consider European and colonial heritage, even if Tangata Whenua would prefer you not to. I will obviously address that as part of the right of reply. I also heard some questions about, I would like to know my tools in the toolbox, you know, what's around.
Look, I still think you should comment on that, but having said that, the question sort of originated because we were yet to hear from Heritage New Zealand, who was the statutory body who would have those responsibilities. Now that they've clarified their position, it may not be as important, but I think it's probably good to clarify.
Thank you. That was going to be my follow-up question was, is there any targeted part of that?
Yeah, I mean that was the subtext of the question, which was, are we going to trip ourselves up because we've ignored a statutory function of another body?
Yes.
and given that that body has now said, well, we've got problems, which is a very loose interpretation of what they said, then, yeah, then
That does
I think
clarify
we'd still
what-
like to be, we'd still like to know.
Absolutely.
Can we agree?
Yeah.
Just before I get into some of my other ones, I will just, I did want to comment on Commissioner Kensington's question about the artificial crop protection structures. I guess there is value in me also being the reporting officer for Hearing 9.
Yes.
That there is, and I absolutely had my position from Hearing 9 in mind when looking at that provision. And the intent behind targeting it to just Te Waimati Kororua and Rangihua being the free rural type zones where you're likely to get this interface into play. I want to be really clear, the intention of that rule was not to stop artificial crop protection structures, and it was not to prevent anybody changing their land use to that type of farming. We know, we've heard a lot today about that soils are volcanic, they have good soils. I've got the NPSHPL in mind as well to say that these areas should be able to be farmed, and the intention of that rule was not to get in the way of that. It was more, I guess I did not recommend in Hearing 9 to require screening of those on amenity grounds. And I think that was very different because in a general rural production zone without those heritage values, the priority has to be the production, the farming and the maximum use of that soil. And the amenity should be driven by, I guess, the operational needs of the production activities in those areas. Where you get these situations where it's heritage values colliding almost with the need to be productive, I was trying to find a middle ground to say, again, just from the public places, that if we could try and provide a mechanism to say, absolutely have these structures, but screen them so that from public roads, and I had Kororua specifically in mind with some of these when I was testing it out. So it was, if you were on a public road and you were looking back towards the maunga, what would you see in the foreground? And that would be a shelter belt potentially, rather than a lot of plastic and netting, in terms of trying to manage the heritage value of what you're trying to protect. So that was the, I guess, the thinking behind it. If the panel have any further questions or would like me to, I can put more commentary in my right of reply, but I'm happy to do more in that space.
Well, again, thinking back to Hearing 9, the question is what's the nature of the screening? The screening is an artificial, I'm assuming you would want the screening from a public place to be vegetation.
The rule as drafted says landscaping or planting.
Yeah, okay. So it remains as that.
Yeah, and if I may, that's also partly in recognition of these. We've heard about the nature of these landscapes. Or also Te Waimati in particular, there wasn't much discussion when you heard it, hasn't come up, but similarly. And so it's the nature of those landscapes where that particular response is seen to assist enhancing the heritage values of the pastoral landscape.
Yeah, thank you.
And maybe the scope for introducing that rule came from submissions actually specifically on Te Waimati. That was the genesis of it.
That's right.
Okay.
Are there any existing crop protection structures in these heritage areas? In the submissions from, and I'm thinking specifically of Sinna Smith and Heather Adams and Duncan Ross, their concern was based on the fact that this is already happening. It's happening. Without screening.
Without screening. There's no requirement to.
Thanks.
Thank you. Just down to here. Yeah, so obviously the issue of farming, which kind of moves on quite well to where we're going, I will be looking at that very clearly from the earthworks angle, as that is one of obviously the more problematic ones. I think Mr. Brown and I have got a few different options on the table. Some of those may be about shifting boundaries of the actual overlay itself. Some may be related to looking at exemptions and seeing if there are specific rural farming practices that require exemptions. But that's not to say we're not also going to be looking at how these rules work in urban areas as well, because these earthworks rules, the way they're drafted, the intent is that they will be consistent across all overlays. So we also have the option of considering, are there rules that work for the rural type, which is really those three main ones, Kururua, Te Waitangi and Rangihua, and do you take a different approach in urban areas, and what does that look like? So please be assured that it's not just a narrow question of is the depth right, it's looking broader than that at what other options are available.
So we can give you the feedback, I think, because I think we generally accept the method. We like the approach, and we're just interested to see how you resolve these other issues.
Absolutely.
Before having to revert back to another method. So we want to
Thank
give
you
you
for
the,
that direction.
yeah, we want to give you the confidence to keep going.
No, I appreciate that. I will make a comment about the Federated Farming's position on soil type. I think my initial position about starting to bring that into an earthworks rule is that probably does raise more problems than it does otherwise. Again, from hearing 9, we know the difficulties in getting accurate soil data and understanding what that looks like and where it is, and a map might tell you is over here, 3 metres that way, and it's changed to something else. So I think for the certainty that you need for a permitted activity standard for earthworks, appreciate where Mr. Hannah was coming from, but I have some practicality issues about turning that into a permitted activity framework, but I will cover that off more fully in the right of reply.
Exactly what we're looking for.
And I know we've talked a lot about Kururua, but we also heard a lot about Paihia. We heard about the Rangitoto Peninsula. So for the areas, for those 3 in particular, I'll talk about Kururua in a moment, but for those 3 in particular, John and I are intending to go away and look at where those boundaries are, and completely appreciate a lot of the commentary that you could almost take those boundaries out as far as you like, because if you were just going purely on where are you likely to find archaeology, you could keep going in the far north and you would pick up so much. And I just want to recognise that those boundaries are really trying to reflect a balance between where is the highest risk of finding things that we don't already know about. And the exact line is always going to, it could be pulled back further, it could go out a little bit more, but the further back you pull it, the less protection that it has and the less land is protected, and the further out you go, you might pick up more, but you cause other problems for landowners in terms of what they can do. So we're actively aware of that tension, and the right of reply, where our final position lies for all of those boundaries, will be based on the trade-offs. And
I think while you're there, I wouldn't mind some comment from Mr. Palmer's evidence. I think when he made the statement, well, they've all got, why have you picked on Rangitoto when everything else, I'm recognising he is not a heritage expert, but he has made a direct challenge to your assessment, Mr. Brown. Yes. You helped if we got a response to that, the proposition that everywhere else around Rangitoto is just as rich. Why are you one for part B, type layer over that land?
Yes.
You helped some comment on that.
Yeah, no, we can certainly provide that.
And while I'm there, you got a number of lay submitters questioning your rationale on the positive financial implications of heritage listing. So I could give you the option to respond to some of that lay evidence if you want to.
Yeah, thank you, sir. Do you want me to respond now?
Oh, well, if you want to respond now, that's entirely up to you.
To provide some clarification around the appendix, it wasn't the intention of the appendix to cover off all in every scenario. Really, I was sort of thinking when I put that together that it's just about raising awareness that sometimes there are economic positives. In this case, it really probably more relates to Part A areas rather than rural production areas in terms of the literature. There's literature tends to focus on those kind of urban values. And I freely acknowledge that I haven't particularly cherry-picked every article. It was just an idea of saying, look, here's a range of articles of the type of thing you might find that explore the principles of it. And I have specifically acknowledged that that was an AI-generated list of probably, and I have read a fair few of them, but it's the main ones that sort of crop up when you're doing the searches, because those are the most common ones. So it isn't my intention to say, here's the evidence and shut up. I fully understand that in terms of perspectives, people will see something on the limb, or they'll see maybe insurance issues in terms of things like that. So and in some cases, in particular with the Auckland examples, individual sites may well decrease in value because of those perspectives. And in fact, I've given evidence in humans provided by with support from economics showing those kind of examples. So I know it swings around us. The key thing is that it's not always a negative outcome necessarily. And Russell's probably a really good example, and because of the degree of heritage tourism that comes there and generates income for the community.
Okay, well, I think it would be helpful to hear through that writing. Thank you.
Okay. Sorry. Something I heard, sort of come out was, if something has a layer of protection, does it need to have, is it real? This is a question I heard from other parties, is does it really need another one? So I suppose that's important, when people want to put some protection layers on for significant sites or whatever. But do you need a bigger umbrella? I'll leave that to you.
Well, I think I don't want to answer the question of the planners, but I do remember you talking according to our report about we don't need a heritage listing here because it's covered by the coastal chapter of natural landscape. So I still obviously stand by that rationale that where there are some areas where there is protection there for another reason, but it has an added heritage complementary protection from the heritage.
Absolutely, Mr. Chair.
You might want to explain that one.
Maybe just a little bit more clarification from Fire Hilda. Are we also referring to different pieces of legislation as opposed to just within the DP? Yeah, thank you.
Could be, I don't know.
Yeah, no, thank you.
I can't remember the specific example, but I do remember reading that by saying there is default heritage protection because it's in the conservation, the coastal side of the coastal.
I would probably clarify that just here, saying I wouldn't rely on any of those layers to say there is default heritage protection, because none of those layers, there are no objectives and policies associated with those layers that mention heritage, aside from, I think, some of the coastal stuff by the New Zealand Coastal Policy Statement does traverse into that realm of it. It was more those arguments we put forward in the 42A report in response to requests by Heritage New Zealand for new areas. So it was more saying, acknowledge that you would like more and you would like this to go further. From an objectives and policies and recognition of the heritage value of that area. And ONL or ONF or any of those layers, that doesn't do it in terms of heritage. But where I was going was in terms of practical kind of management of those areas. A lot of them are already managed for colour. A lot of them are already managed for buildings. Yeah, already setbacks. So it was more in response to requests to push further for more layers, to say maybe they do have heritage value and heritage merit, but I'm not minded to say yes to those, because I don't think there's enough evidence spatially that people would have understood what was being asked for. But as a secondary reason, practically some of these issues are managed by other overlays, just in terms of the way the rules work. But in my right of reply, I'm happy to provide a bit more commentary as opposed to if it's already protected in another way. Initially, I'll be quite honest, for say that Te Maki, Flagstaff Hill is a really good example where I wrestled with do we add it or do we not, because that's already part of a heritage reserve. You know, so practically it's got heritage protection. Do we really need another layer? But in the end, for that particular site, I came down on the side of recommending inclusion. Because it wasn't in private ownership, so it wasn't other landowners who would suddenly be surprised by this, and because it is so clearly connected to the heritage areas of Kororareka Russell that it felt like an omission to leave it out. But that was a very site-specific, I guess, case as to why I did that. And Waitangi Islands were very similar. Yeah. But actually, continuing on Kororareka, I think hearing from Mr. Riddell was really helpful, and I think there have been, I guess, some translation issues in terms of what sits in the zone versus what sits in the heritage area overlays. Obviously, that sort of layering in the operative district plan, the two of them worked more as a pair. So I will be looking at how I can make those work better and clearer too. The intention, as I understand it from what was originally notified, was not to deviate that far from what the operative district plan, it wasn't intended to suddenly make it a heck of a lot more stringent. In saying that, one of the reasons why the Part D has generally landed in more of the Part A type rules rather than the Part B type rules is on the recommendations of Mr. Brown, where obviously the Environment Court came down on the side of you have A, B and C as the core and D as the buffer. And I might let Mr. Brown speak to this in more detail, but it was Mr. Brown's position that actually D had value in itself, and that call it a buffer of a, maybe underselling it in terms of its value. And so there was a move with D to make it more, I guess, maybe than just a buffer area, if you'd like to.
Yeah, I can elaborate on that. So we saw actually helpfully from HNZ those views looking from the harbour back towards township, and you could see how that township went up toward the ridge lines, and that's kind of where the property is going. Experientially, as you're walking through the street, you're literally crossing from a Part C or Part A into that section. So from my point of view, I didn't see experientially in terms of the heritage experience or the values there, why that should be treated differently. And so my view of it when I did my site visits was that, well, in fact, this is the kind of area where you come down into and begin to experience the township in relation to its historical context. And that was why I considered that element should be subject to a similar approach.
I might move on quicker because I can see we're getting close to 3:30. Just with the last two things to say, yes, I will be turning my mind to heritage alert layers and the infrastructure. The only things I would say very quickly is that the heritage alert layers, I think they come up against some very similar spatial issues with being recorded on titles and shown on maps, which was the source of some of the concerns raised that we've heard from the community and the landowners over the last 2 days. So I'm not sure it really gets us away from that. What I will say is that I have recommended, if the purpose of them from Heritage New Zealand's perspective is to improve visibility and let landowners know what their obligations are under the Heritage New Zealand Kohototanga Act, my recommendation is that you do that by the way of advice notes in the relevant rules where that is really critical in terms of what's under the ground. So that's HAR 5 and HHR 5, which are the two earthworks rules across the two chapters. So there's a new note in both of them alerting landowners that when they're looking to do earthworks in those heritage area overlays, I mean, admittedly that only works in heritage area overlays, not in the broader alert areas, but that was really my signal. It can't, I guess, help with areas outside of heritage area overlays, which sounds like that's more Heritage New Zealand's concern, but that may be, obviously we've already had the earthworks hearing, but it's an issue district-wide.
Yeah, I think the main thrust of their alert layer evidence was areas that aren't protected. And I think we're really interested in the pros and cons of having that non-statutory layer. Canvas pros and the cons. We just like to hear it from you as to whether, whether A, you think you can support it, and if you do, how would you do it? But obviously,
Yeah.
That will definitely be covered. And then the last one is absolutely we'll be looking at infrastructure and the top energy evidence. The only thing I want to say to finish off is that completely understand that it is an internal process and it's specific to top energy. The rules are broader than top energy. The rules are for infrastructure. That's telecommunications, that's pipes, that's it's a lot broader. And so one organisation having a really, really good, robust process is brilliant, and it's best practice. And it's the sort of process that the resource consent and the rules, that's the outcome. The outcome of that resource consent process would be to make sure that everybody does that, not just top energy. And as you say, if it's not top energy in the future, or it's a different iteration of top energy, that requirement is carried on. So that will be where my right of reply will cover off.
just two questions for Cora, right? Guidelines.
Yes.
And if they, the square area of the building.
Oh,
The footprint, yes, those will be both.
Brain fade and.
The building area ratio. Yeah, full area ratio. No, those will both be covered. The design guidelines issue, I think it's really hard when people just talk about the design guidelines, because there's actually two parts to it. There's what was in the operative district plan, what was sitting in that assessment criteria part, and then there was the standalone 2007 document, and that 2007 standalone document has never been part of the district plan. Not part of the operative, not notified as part of the proposed. I appreciate Mr. Riddell not appreciating my interpretation of the assessment criteria and attempting to translate them into the PDP. I've tried to take it further than what the proposed plan as notified did and bring through some more of that flavour and that guidance and put it into the policy. I think just from a drafting perspective, I was trying to make it clearer, more refined, more targeted, as opposed to maybe some of the, and obviously we maybe differ with our, how detailed Mr. Riddell maybe would have liked my drafting to be versus where I was comfortable drafting, but I'll be looking at that and that relationship between policy P6 and how that's referred to in the matters of discretion.
Anything about FAA?
Oh, that will be covered. Oh, not that I'm commenting on right now.
Thank
And
you.
that's all for me.
I just had something totally irrelevant, but to do with top energy, and they were talking about arborists and all the civil emergency stuff, with all the weather. It's got nothing to do with this, I suppose, but they really need to have them around different parts of the farmland. Like, it sounded like they didn't want to have one on board, but what other communities are saying is that we want someone nearby. If something falls over in Pangaru, they've got people who could do it, rather than waiting 2 or 3 days and the tree's a risk. Like, we'll get rung to say there's a tree leaning over at such and such a site, and it could hurt someone just because of the weather. So I suppose that's got nothing to do with anything.
Not my topic, but that is.
But the arborist thing, I just found that strange about being. That company makes. It's not competitive.
Yeah.
Okay. That makes a lot of money. I'm sure they could afford arborists in various parts of the north. Yeah.
It's correct, isn't it? Most of the trees are in urban areas.
I think you're looking at the wrong report.
Yeah.
I'll let you answer the
Question.
Is the majority of urban trees in urban areas?
I couldn't 100% say, but I think so. There are some out in the islands and stuff.
Yes, sure. I mean, there are other ones, you know, I mean, particularly we were talking about that, you know, our first study yesterday.
I would suggest that of 176 trees spread out across the entire and varying environments, urban where we heard from Top Energy that most of their assets, they either want them to be underground or will be underground or in isolated positions in the islands. I would say the numbers game is pretty low.
Right, thank you very much, Ms. Oh, you were not finished?
No, I was just about to hand over to Ms.
No,
Lockhart.
yeah, well, first of all, thank you very much for all the work you've done up until now. You've been very informative and helpful. Teresa, you're next.
Yeah, can we just in the interest of time and ensuring Golly Clara gets to, so yeah, I'll just go quickly through my just total for Melissa, my colleague Melissa, and saying that I've very much had my listening turning on and my listening here all the last 2 days, and it's been very informative, but just go briefly through my verbal right of reply. I just address the repeat on the procedural matters I highlighted at the beginning of the hearing regarding to Appendix 1.2. Mr. Hayes's evidence in regard to the already listed site of an area of significance to Māori in Tortola North. The question of what FNDC's responsibility in terms of implementation and looking after listed sites. I will look at and address in respect to Top Energy. We've just talked to, they raised the point of wanting new objectives, policies and rules. I've reached out to my colleague Jerome, who did the infrastructure chapter, because that's where I alluded to that's where it would have been taken care of, and I will continue to investigate whether that has happened or not. In respect to Arawai Limited's request to remove a listed site from the schedule, that will need further investigation, the issue of, you know, the live consent issue and the issue between the landowners of Okakuri A and Okakuri B will need to be investigated. Today's evidence from Te Ao Pōri, I really want to acknowledge the depth and feeling expressed by Te Ao Pōri in respect to their evidence and the issue of manawhaka haere. And, you know, at this point, I just need to say, yeah, taku here or tamato here in terms of the urge that has caused on behalf of council. The last but one, I think I want to raise is, I guess there's a tension. It's what we're looking at in respect to significance to Māori is the complexity of multiple interests in sites, the issue of natural justice in terms of requests to update, review, remove, and so on, and the tensions around the righting of a perceived wrong, and then that we do that. When we do that, we don't create another perceived wrong. That's the tension I think we're dealing with. And my last issue is respect to something that no evidence has been presented at this hearing in relation to Moringai at Ahipara, and in my 42A I raised some questions that can be answered on. So procedurally, I'm not sure. Yeah, it'd be good to have some guidance from people about what I need to do next in respect to that, if no evidence has been presented to. It also, that side also raises the issue of, do we need more layers of protection? It's already, the tree's already scheduled in Chloe's chapter as a notable tree. It's already a historic reserve owned by council. They've requested be assigned areas of significance to Māori. We don't have an issue with that so much, but I've got questions about requesting party extent and so on. So some guidance from Peter.
Would it be okay if I organised some of the Moronai hapu to meet with you, because there were a whole lot of questions written a couple of years ago, and some of it's been resolved, but some things are still not resolved. And I can't think offhand what they are, but
I think you find it in the report, there are a few things, I highlight a few things that maybe, I just don't know.
the notable tree one.
Yeah.
And this is, I think somebody brought it up yesterday, is about you have a Ahipara Takiwa, which is 3 marae, had listed the Pohutukawa in their IHEM.
Yes.
But it didn't transfer over to the notable trees list. And that's where all the fuss happened. And the fuss was, if we've already, and so I don't know who spoke about this, I've already forgotten. But you know, if it's in the hapu agreement, then how does it translate over? Because people don't want to write another application form. It should sort of, you know, translate over, or somebody is going through the documents and saying, this is where this is protected, here. Otherwise, you're asking people to write something 2 or 3 times. Just saying. Do you want me to organise with those, because I don't know what's the process?
I don't know where we are procedurally on that. I'll get back to you.
I think it could help if those people were to have a conversation with you. I'm just not sure whether it's appropriate for you to organise that. But
I mean, I can.
I was going to say, you can reach out to them, I would think. Yeah. Just make sure that all parties that you think are interested in are engaged. We don't want to leave anybody out, but I don't need to tell you that.
No. So, colour it in.
Slightly mansplaining that one to you.
It's not mansplaining when it's asked for, Mr. Chair.
But that point about the notable trees, if it's in an iwi hapu management plan, is there a way that somebody's looking through these documents, even if they're out of date because they're still supposedly current, that, you know, like any sort of corresponding stuff can also, with permission, be moved to your so-called list? Or
what I would say is the process should be that we would, in developing our plan and reviews of the list, that we should be obliged to go through all those documents, and we should. So,
oh, sorry, if it's all right if I respond. I can advise that the iwi management plans were read when we were drafting the proposed district plan, and where a tree was mentioned, we endeavoured to include it. One of the challenges we found is there's not a lot of trees identified. So what we'd be keen to do is communicate that back through the appropriate channels to say if we could have, if some greater information could be provided, it would be very helpful for us when we come to do plan changes to understand what trees are important and should be protected. There seems to be a disconnect at the moment.
Yeah, I think it's an issue of implementation of the environmental management plans through the organisation. So what's the process of that when they're received into council? How are they socialised through, you know, through infrastructure, through district planning, through consenting, and how are those plans socialised? So all of that as branches of council, because they're broad-ranging documents that apply across the council. So how are we informed about what's in, that's the issue. Yes. Thank you. Thank you.
Thank you. So we have to.
Yeah.
Great. Thank you again. Thank you very much for your skill in presenting and answering our questions and conducting it. Awesome.
Chloe.
I just have one matter to highlight. The panel identified an inconsistency in Appendix 3 for notable trees, where a tree number 137 was marked for deletion, conflicting with recommendation in the section 42A report. I acknowledge this error and maintain my position as outlined in the section 42A report, and will correct this matter. In my own reply. In regard to the other evidence, I will review it and reply in my reply. However, I generally maintain my position outlined in the report.
Oh, very good. Well, all I can say is this is your first hearing, isn't it? Well done. I think, talk give her a round of applause. No, very good. You're very well written hearing report, and you provided the panel with some excellent answers to our questions and responses to the evidence. So well done. Keep it up. Look forward to seeing another one, I hope.
We'll find a rather large rezoning for you.
I'm pretty sure the plenty of planners will need to delegate to you.
Chloe is an integral support to the planning team at large.
Yeah, just to support Chloe's position, there's a number of recommended amendments from FNDC. We'll address those. Many of them, like the proposed objective, is potentially just protect trees, except when you want to get rid of them. So we'll be responding to that, Mr. Chair.
Was that a response to that particular policy that I talked about yesterday? Yeah. Okay, good. Well, I'm glad that have some attention. Is there any other matters? Thank you. I think it's a really, really good response again, as always. Shall we wind it up now, folks?
Yes.
Who wants to do a karakia to close?
That's me. Tiona hoki te mihi mahana ki a tātou katoa. Tēnā koutou ki te hearings panel o mahi tēnā he o i tēnā. Nā rā, tēnā koutou ki ngā kaimahi o te kaihea o te raki o mahi hoki, mahi pai, haringa haumaru, ki o kāinga i tēnā ahi, karakia tātou. Kia tau, kia tātou katoa. Te ata whānau tō tātou arakia ihu karaiti. Me te aroha o te atua, me te piri mo tahitanga, ki te wairua tapu. Ake. Amen.
Stop the recording.